My gavel hasn't arrived yet. Oh, is it? Oh, I got to use it then. Okay. Good morning and welcome to the meeting of the Board of Psychology. Ms. McCorcoran, could you please call the roll?
Sure. Phillips,
Aye.
Jones,
Here. Whatever.
Good morning here.
Akwebadu, Bernal, Kasuga,
Here.
Erickson,
Good morning, here.
Fu,
Here.
Horn.
Here.
The quorum is established.
Thank you very much. As I said, welcome to this morning's meeting. This is a meeting of the California Board of Psychology. The Board of Psychology's mission is to advance quality psychological services for Californians by ensuring ethical and legal practice and supporting the evolution of the profession. Our values are transparency, integrity, consumer protection, inclusiveness, excellence, and accountability. Just a few brief remarks before we begin on the board's agenda for this morning. Number one, for those of you that have not been in this particular room before, it is perfectly permissible to bring water in here. It is not permissible to bring anything but water in here. So if you've brought some other kind of beverage with you, please don't crack it open during the meeting. The second thing I wanted to mention was we've recently become a Paperlight, or moving in the direction of becoming a Paperlight office. So many of us are using laptops or tablets for purposes of these meetings. So if we're looking at the computer screen, we are not serving the net. The other thing I'd like to do before we commence on the agenda is to observe a minute of silence in honor of the people that recently lost their life in Florida. Thank you. We're going to take things a little bit out of order with the agenda this morning in order to allow Mr. Ito to make his cameo appearance here. There he is. So the first agenda item we're going to take is the budget report. That's number 5.
Good morning, Board President, Board members. I'm excited to be here this morning to present your budget and alleviate any concerns you have regarding your budget. All programs under DCA participate in incremental budgeting, which means that the starting point of your budget is the prior year's Budget Act, which is signed by the governor. So in layman's terms, what that means is we don't start at zero. We start where we left off in the previous year. Now, these incremental changes are made via budget change proposals, executive orders, budget letters, etc. And the end result is a current year appropriation of $5.107 million, which is the figure included in the governor's budget for this fiscal year. So in your packet, you have a variety of documents that I'm going to go over today. The first one is your expenditure projections. It's the one at the top of it. It says Board of Psychology Budget Report. Fiscal year 17-18 expenditure projection. Now this document shows your prior year actual expenditures. It also shows, in your first column there, it shows your prior year actual expenditures for month 13, which is the end of the year expenditures by line item. And the next column shows your expenditures at this time of the year last year. So, which is for FM6, which is the expenditures as of December 30th. And the next column is your budget allotment for 17-18 by line item. And then the next column is your current year expenditures. Now let me kind of explain where these current year expenditures come from here. So we do not have a fiscal month 6 or 7 fiscal expenditure report at this time. However, I am able to manually extract a majority of the data out of the system or through reports that we receive. So I am able to get 85 to 90% of your expenditures actuals. And these are kind of your big ticket items, your personal services, your facilities, your pro rata, and your enforcement costs. And then for the data that I can't get out of the system at this point, I use prior year data just to kind of project for this year, and that's that small percentage that I'm not able to get. And with that said, I'm showing a reversion or a savings this year of $138,000 based on that. Now we are now back to the fiscal reports. Fiscal month 1 report was released and sent to your board at this point, and we're kind of anticipating a waterfall approach where the rest of the reports are going to start coming out more expeditiously. And our hope and what we think is going to happen is by your next meeting, we'll be completely caught up on the expenditure reports and we can give you a projection based on your actuals for every line item. So, so with that said, based on the data that I can extract out of there, and it's 85 to 90% of your budget, I'm showing that you are going to have a reversion that's within the healthy range that the budget office looks for. So if you have any questions about the projections, I could take those. I'll take those at this point. Okay. So the next item we have, it's your discretionary versus non-discretionary budget. It's the chart the title is the Board of Psychology budget items. So this just shows your complete budget, and I break it down by what's discretionary and what's non-discretionary. And the intent of this chart is just to kind of show that the majority of your charges are non-discretionary. It's expenditures that you don't really have any control of. So so the board's doing a good job with their expenditures, and they don't have a control over the majority of them here. So, all right. And then our next form here is your fund condition here. It's the one that's titled 0310 Psychology Analysis of Fund Condition. So this form, there's 4 separate sections in here. The top section there is your beginning balance, and it shows data from fiscal year 16-17, which is your actual data from last year, through 19-20. So the first section there is your beginning balance, and that shows what your beginning balance is at the beginning of each of those fiscal years. So it's actual for last year, and then it includes what's in the governor's budget for 17-18 and 18-19, and then there's projections for 19-20. And then the second section down below there is your revenues and transfers. That is your revenue. And once again, for 16-17, that's going to be your actual revenue that you brought in. And then for 17-18, 18-19, that is your projected revenue that I work collaboratively with the board to come up with those projections. And then for 19-20, we just straight line those out based on your projections from the 2 previous years. And there actually is another section there for your general fund loan repayments. Now we anticipate that $3.8 million will be paid back in 18-19. That's the plan at this point, and you'll have $2.5 million paid back in 19-20. Now, as I've talked about in previous meetings, those general fund loan repayments, that is something that we reassess every year based on need. So right now we're planning to have them come back in 18-19 and 19-20, but based on what your fund reserve is and your months in reserve, we may adjust that either forward or back depending on what you guys how you guys are looking. And then the next section there is your expenditure section. That shows your appropriation and any direct draws that hit your funds directly. So we have your appropriation, your fiscal assessment. We have your statewide pro rata is a direct charge to your fund. And then there is a supplemental pension payment that comes out of your fund now as well. And then the last section is your fund balance. That shows what your projected fund balance is going to be at every one of those fiscal years. And we've talked about this at prior board meetings. You guys are working in a structural imbalance where you're spending more than you're bringing in. However, you do have that safety net of those general fund loan repayments that are going to be coming back in. So at some point after the general fund loan repayments come in, and if you're still working in that structural imbalance, you'll need a fee increase at some point, but that's going to be pretty far down the road because of those loan repayments. And then when that happens, we'll work with the board to make sure that we go down the proper avenues. So if you have any questions about the fund condition, take that out.
Good morning.
Good morning.
You mentioned that those are the planned transfers currently.
Yeah.
What would disrupt that plan? What are the criteria or the guidelines that would affect that plan?
We usually look at your months in reserve, and your months in reserve kind of depend on what your fund balance is. We look at your projected fund balance to see if it needs to be paid back sooner or later. So that's something that we reassess every year. It's not a rule of thumb, but if it's something between 0 and 6 months, probably we would take a hard look at it to see if it should come back in. Yeah. All right. So the next documents here, it's actually a few pages here. So these are the bar charts here. So the intent of these charts is to kind of tell a story of kind of what's going on with your fund condition in your fund. So the first chart here shows your budgeted revenue and expenditures. So it shows what you're projected for revenue and what your budgeted expenditures are. So that shows if you brought in exactly the revenue that you project on your fund condition and you spend your entire appropriation. The first chart kind of shows what would happen. So for instance, in 17-18, you're projecting $3.98 million in revenue. And if you spent your entire appropriation of $5.107, your structural imbalance would be $1.403 million. So the first chart kind of shows if it goes according to the fund condition, this is what's going to happen. Okay? So, and then if you go to the next sheet shows actuals. So that shows what your total revenue was for those years from fiscal year 2011-12 through fiscal year 2018, and it shows your actual expenditures. And then the third line shows your actual fund balance. So it shows that you're still decreasing because you have a structural imbalance, but it's not to the level of what the fund condition says. Because most boards kind of project conservatively on the revenue because you don't want to over-project your revenue typically. So this shows that there's still a structural imbalance, but it's not to the level of what the fund condition shows. And then our third chart here shows for expenditures, it shows that top line there is your budgeted expenditures. So in layman's terms, that's how much you can spend every year. And then the second line shows what your expenditures actually were. And then the third line shows what your reversion was. In other words, it shows what your savings was for every one of those years. So you guys save every year. You used to save a lot more, but you've been filling positions, and so your reversion's gone down, but it's still in a healthy level. It's not like we're sweating it at the end of any fiscal year. And then our last chart here is for revenue. It shows your projected revenue versus what you actually bring in. So the top line there is what you project every year, and like I mentioned earlier, I work with the board to project the revenue, and then the second line is what you actually bring in. So you're actually bringing in. So this chart shows that you're actually bringing in significantly more money than you're actually projecting. And with that said, I am done with my presentation. I'll take any questions you have at this point. Yeah.
Good morning. Thank you, Mr. Ito.
Thank you.
I appreciate your presentations every year, and I feel like I understand them each year a little bit better and better, so thank you. And I guess back to the question that Mr. Fu asked about the loan repayment and the fund balance. I'm asked the question to you, but I guess also Ms. Sorek, maybe you might also have a thought on this. I know that several years ago when we started asking a lot more questions about the fund balance, the question was about how we could ensure we were providing the best services to licensees. Mm-hmm. And so I know we did a couple of BCPs. I'll use the lingo. Yeah. The budget change proposals. And I know that you just mentioned about us not saving as much, right? Yeah. As we were doing more. So I just want to know in terms of, I know we'll get to your report at some point tomorrow, but I know in terms of the vacancies, I mean, how are we in terms of that planning? Are we going to do another round of those, or do we feel like we're at capacity? And again, maybe it's not the right time to ask this question, but I know that you guys work closely together, just thinking about budget.
Okay. So for those prior BCPs, just to kind of touch on how you filled positions and how the reversion's gone down. You've done a couple BCPs where you requested positions without any additional funding because your board was able to absorb those additional costs. But moving forward, based on your reversion, if you do request additional positions, I'd imagine we'd be also asking for those additional expenditures to be added to the appropriation. Yeah.
Or in the similar train of thought, which is, if there's a change in the economy and there's a change in the overall condition of the budget, that would affect the transfers that the board receives. Is that correct?
Well, every year when we work on, we reassess your revenue every year because you have a certain amount of money in your fund. If you're anticipating a change in the economy and maybe a change in the number of licensees or folks that are going to renew, because that's where your revenue is coming from, I'd work with the board to make sure that the revenue is on par with what we're projecting in the fund condition. And then we can go from there.
To clear. Okay. The primary source of revenue that we have is coming from our licensing fees, which generally stay relatively even over the course of time. There are also citation fees we get and other fees of that nature, but the vast bulk of our budget.
Yeah, the site and fines can be volatile, but I don't have your revenue by line item in front of me. But for the most part, I think I can say with a certain amount of certainty that most of your revenue is from your licensees for applications and renewals.
Great, thank you.
Good morning. To address Ms. Jones' question, we have added additional staff through the budget change proposal process, and those were blanket positions, so we didn't ask to take money out of our surplus to fund those conditions in the past because we've reverted money each year. So, and typically you have a little more success when you're asking to use blanket funds versus taking money out of your surplus and getting those funds. We had 2 manager positions, one manager position, and then we had 3 licensing positions before that. When we had our backlog, at that time we had 16 weeks, and now we're about 1 to 2 weeks with our licensing timeframes. But we have seen an uptick in complaints, and you'll hear more about that tomorrow. We have a limited term associate government program analyst position we're looking to fill right now, and possibly that will be something we'll go through the budget change proposal for, to make that a permanent position if we see the trend continue to go up in complaints, so that we can manage that workload.
Thank you, Ms. Ork. And I guess I really was picking up on your comment, Mr. Ito, that you said at some point down the line, nothing immediate, we would probably have to review the licensing fee. And that's the reason why, because I know that was part of our conversation as a board. We wanted to ensure that we were giving, I don't know if the right term is value, but I know that, and I guess that was the whole question too, to make sure staffing, if our executive officer felt staffing was at the right level. So thank you for sharing that. And I know there's I forget what the trigger is, but I know it from the previous reports that we would then review that process.
Yeah, and then at that time, we would determine if, in order to raise your fees, if it would have to be done through legislation or regulations. At this time, I'm uncertain, but I can go back and look, and I can get the antenna on that.
Questions or comments from board members? Are there any comments from the public? Hearing none, I'd like to thank you again for making your visit, Mr. Ito. He's our budget manager, and we very much appreciate your work on our behalf.
Awesome, thank you. I'm always excited to come here to present.
Thank you.
Have a good day.
We're going to take this a little bit out of order because we do have several disciplinary hearings today for petitions, but I did want to go to item number 3, starting back where I left off. There'll be public comment for items not on the agenda. Again, I remind my colleagues who have heard me say this innumerable times, we may not discuss or take action on any matter raised during this public comment section. Is there any member of the public that would like to make a comment for items not on the agenda? Seeing none, we are going to move on to item number 4, which is the approval of the board meeting minutes. Keeping my eye on the clock because we have a hearing scheduled to begin at 9:30.
Thank you, Dr. Phillips. I had 2 corrections on line number 51, where it reads, Ms. Jones stated that the agenda item would be postponed. I actually confirmed that it would, or asked, because that was the decision of the president. So if we could just change it from stated to inquired about that change. And then on line number 128, make sure that's the right line. Yes, for Friday, November 17th. I was not present, so that should be removed. Rather.
Dr. Horn?
Thank you. On line 327, licensee who decides to go into retired status has 3 years preceding to be able to go back to active status. What does that mean, 3 years preceding? That I don't think that's accurate, is it? Isn't it after you go into retired status? You have 3 years in which to do it, so that wouldn't be preceding. That would be
Gwen?
from that time or subsequent, yeah. And then that might be all the substantive things, but I think there was one more, so hold on. That's it. I do have some just grammatical things that I'll just turn in, but thanks.
I'd also like to make a correction to line 1391 and 1392, where it says Dr. Phillips stated an ad hoc committee comprised of at least one board member and professional organizations will be formed. It actually is and relevant stakeholders. It's much more broad than professional organizations, because there's obviously a lot of people that are concerned about whether we're going to adopt the EPPP2 and how it will impact them.
Here I think I included members of rather than associations or something.
I'd just rather say stakeholders, I think, relevant stakeholders.
Stakeholders is definitely better, yeah.
Are there any other comments on the minutes from board members? Okay, hearing none, would someone like to make a motion?
I'll move that we accept the minutes as amended.
I'll offer a second.
Okay,
Approve the minutes as amended. Sorry.
do you want to resecond?
I will resecond
Okay,
the revised motion.
thank you. Are there any comments from the public, any on the minutes? Are there any further comments from board members? Hearing none, Ms. Corcoran, could you call the roll?
Phillips,
Aye.
Jones,
Aye.
Kasuga,
Aye.
Erickson,
Aye.
Fu,
Aye.
Horn.
Aye.
And it's been approved.
Thank you very much. The motion passes unanimously. We are going to be starting a hearing at 9:30 on the matter of Mr. Jimenez and his petition for early termination of probation. Rather than go on to another budget item, I'd like to give the respective parties an opportunity to come forward and to get themselves set up in advance of the meeting beginning, or the hearing beginning. So we'll take a 5-minute break. On the agenda at this moment is the petition by Dr. Jimenez.
All right, good morning. On the record? Good morning. We are on the record. It is February 15th, 2018, in the matter of the petition for the early termination of probation of David Jimenez. This matter is being heard before the Board of Psychology, Department of Consumer Affairs, State of California, Office of Administrative Hearings, case number 2017-120990. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings. I'll be presiding over the matter this morning. Will all the members of the board please state their appearance for the record, starting to my right with the president, Dr. Phillips.
Dr. Stephen Phillips.
Nicole Jones.
Dr. Michael Erickson.
Dr. Cheryl Kasuga. Lucilla Quabidu.
Dr. Jacqueline Horn.
Iran Fu.
The quorum of the board is present. May I please take the appearance of the Deputy Attorney General?
For the Attorney General's Office, Jansen Tan, Tan Tan.
Right, and Dr. Jimenez, you're here today representing yourself, is that correct?
That is correct, Your Honor.
I'm just going to briefly explain how the matter is going to proceed this morning, and then if you have any questions, you can ask me at that time, all right?
Of course.
All right. So, Dr. Jimenez, you're here today because you filed a petition for the early termination of your probation. In this proceeding, the board is concerned with any rehabilitation that you have undertaken since your license was disciplined. The Deputy Attorney General, Mr. Tan, will proceed first by submitting the petition package for the termination of probation into evidence, and he will give just a brief orientation of the matter for the board's benefit concerning the history of the discipline of your license and the petition package. After that, I will swear you in, and you will have an opportunity to make your presentation. If you brought any additional documents with you this morning, then you would be able to present those documents at that time. I will mark those as exhibits, and the board will have the benefit of looking at those documents as well. I just want to remind you that the board has the benefit of having reviewed your petition package, so you don't have to repeat everything that's in that package. But of course, if there are items that you want to highlight for the board and discuss, then you please feel free to do so. After you have made your presentation, Mr. Tan will have an opportunity to ask you some questions. And then after he's done asking you questions, then the board members will also have an opportunity to ask you some questions. I will then allow you to provide any additional testimony that you want to give before the close of the presentation of your matter. After the hearing, the board will go into closed session at the end of the day to deliberate. You will not receive a decision today, but you will receive it sometime in the future. And I'll have you speak to Mr. Tan about when you might receive that after the board has issued a decision. I cannot provide any legal advice during this proceeding, but if you have any questions about the procedures, please ask, and if I can answer the question, I will.
I understand, Your Honor.
Any questions?
No, not at this time.
Mr. Tan, do you have the petition package?
I do, Your Honor. May I approach, Your Honor?
You may. And Mr. Tan, a copy has been provided as well to Dr. Jimenez
Yes, Your Honor.
and all the board members as well.
Yes, Your Honor.
Right. All right, if you would please walk us through the exhibits that are contained in the petition package.
Thank you, Your Honor. First off, Your Honor, good morning, members of the board. Good morning, Your Honor. Good morning, members of the public. Mr. Jimenez, I'm appearing on behalf of the Attorney General pursuant to Government Code Section 11522. I'm here to assist the panel in fact-finding. My role is not adversarial, but is intended to protect the public interest. I'm here to ensure that the panel has adequate information for which to make a decision. Your Honor, with that said, Your Honor, I'd like to introduce the jurisdictional documents, starting with Dr. Jimenez's petition for early termination. That would be found in Exhibit 1, Your Honor.
Dr. Jimenez, with regards to each of the exhibits that Mr. Tan identifies in the petition package, I will ask you if you've reviewed the document and if you have any objection to any of the documents.
Of course, Your Honor.
And you must have a legal basis to object to a document, but if you have an objection and you don't know what the legal basis is, just please tell me. I'll get more information from you, and then I'll make a ruling on how the document can be considered.
Of course.
Mr. Tan.
Thank you, Your Honor. Exhibit 1 is Dr. Jimenez's petition. In his petition, we have his opening statement on page 5, his disciplinary action information sheet from page 14 onwards, his evidence of rehabilitation sheet from page 19 to page 22, his closing statement from page 23 to 24, and other attachments.
Correction, Your Honor. My closing statement ends on page 22 of my notation. I'm 25, rather. I'm sorry. 22 through 25. I think I heard you say 24.
Yes. Your Honor, for the purposes of this hearing, Your Honor, we will be using the AGO page designation
I see.
on the bottom right corner.
Thank you for clarification.
Now, Your Honor, we will go through this whole petition later in much more detail when I cross-examine Dr. Jimenez, but for purposes of jurisdictional purposes, Exhibit 2 is the notice of hearing. The notice is Dr. Jimenez. Exhibit 3 is the decision and order and the accusation which gave rise to the discipline. I'd like to give a brief synopsis, Your Honor, of the accusation for the benefit of the board. The discipline in this case is a license revocation stayed with 3-year probation with terms and conditions, including a prohibition from performing child custody evaluations, retaking the CPLEE examination, an educational review, some coursework, an ethics course, and other standard terms and conditions. Now, the genesis of this case can be found in the accusation, which is page AGO 359. It's also an exhibit to the decision and order. Petitioner was appointed as a custody evaluator whose duty was to make a recommendation for child custody. The parties, the father and the mother, were to submit for a full psychological evaluation. The accusation alleges gross negligence while acting as a court-appointed custody evaluator. It was alleged in the accusation that Dr. Jimenez, repeatedly exceeded the scope of his role as a custody evaluator. He undertook communications, activities, and interventions reserved for that of a special master. This included making inappropriate interim recommendations, issuing directives to father, and intervening into the relationship of the minor patient J.A. and his psychiatrist. Petitioner was also charged with gross negligence for bias towards the mother and gross negligence in violating patient J.A.'s confidentiality by providing J.A.'s psychiatric treatment records to both mother and father. On page AGO 366 of the accusation, we have the specifics of the allegations. For example, Dr. Jimenez made biased and overreaching recommendations that favored mother solely at the mother's request. For example, preventing a boat trip by J.A. with the father, stopping the father from making certain activities, making a life mask for J.A. and other activities. Petitioner also accepted payment from mother only, showing bias, making ex parte communications to the mother and the judge without the father present, reviewing documents that were not copied to father, increasing psychiatric appointments without consulting patient JA's psychiatrist. Petitioner also produced 247 pages of JA's confidential psychiatric records to both father and mother without protecting confidentiality. This led to the patient JA psychiatrist stopping the patient relationship with patient JA because of the loss of confidentiality. Petitioner also misrepresented the status of father's complaint to the board, to the courts, and tried to perform the bulk of his activities while the father's motion to remove him was pending. These are all allegations in the accusation, which we will, Your Honor, I intend to cross-examine Dr. Jimenez on later as evidence of rehabilitation. On Exhibit 4, we have the probation report. That's Exhibit 4 and 5, actually, Your Honor. Exhibit 4 is the probation intake form, which shows Dr. Jimenez's initials on page AGO 504. This means that he's read and understood the terms of his probation. Exhibit 5, we have the probation report. Of note, Your Honor, in the probation report and members of the board, is AGO page 374, condition number 3. Initially, Dr. Jimenez failed the CPLEE examination on or about October 31, 2016, and as a result, Dr. Jimenez's probation was told for 1 year from December 1, 2016 through January 30th, 2017. Dr. Jimenez did successfully take and pass the CPLEE exam on or about January 27, 2017. So this probation condition has been met. Of course, Your Honor, because the probation was told for about a year, Dr. Jimenez's completion date has been adjusted to January 16, 2019. And we'll go into more detail into that, Your Honor, later when petitioner testifies. Exhibit 6, Your Honor.
Excuse me, Your Honor. May I comment on Exhibit 5? Or should I wait until the DH?
Would you wait, please? I'd like Mr. Tan to
course.
finish just walking through the exhibits, and then if you have any objection to a document, you can say so at that time. If you just want to make a comment as to that document, you can do so during your testimony.
Thank you.
Mr. Tan.
Thank you, Your Honor. Exhibit 6, we have the results of the CPLEE examinations that Dr. Jimenez initially failed. On Exhibit 7, we have an email to Dr. Jimenez regarding the tolling of his probation. On Exhibit 8, we have the exhibit with Dr. Jimenez passing the CPLEE examination. Exhibit 9 is the quarterly reports of compliance. And Exhibit 10 is the letter from the evaluator regarding completion of the educational review of Dr. Jimenez as a condition of probation. Your Honor, after going through the exhibits, Your Honor, we would like to move all of these exhibits in evidence, Your Honor.
Dr. Jimenez, any objections to exhibits 1 through 10?
Only through the DHE's oral representation that I was told for 1 year between the CPE Administration 1 and CPLE Administration 2 is actually, I took it initially in October, I passed it the next January. It was just a 2-month period more or less between administrations.
Right.
And
As I mentioned, you can provide that explanation
oh, I'm sorry.
during your testimony when you were under oath. At this time, I'm just going to be moving the documents into evidence. The documents speak for themselves, so any representation that Mr. Tan may have made that you believe is inaccurate, you can certainly explain.
That's fine. I
Right. Any
apologize.
objections to exhibits 1 through 10?
Negative.
Exhibits 1 through 10 are admitted.
Your Honor, because the burden is on the petitioner, I have nothing further at this time. However, I do reserve the right to question the petitioner.
All right, Dr. Jimenez, it's now your opportunity to provide testimony. I'm going to have you please stand and I will swear you in. Please raise your right hand. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please have a seat.
I have additional documents for the board at whatever time I can present them.
This will be your time, but what I'm going to have you do first is I'm going to have you sit down and I'm going to have you state and spell your name for the record so we have a clear record. And then if you have documents to provide, you can approach at that time, provide those, and then we'll go from there.
Of course.
All right, please state and spell your name for the record.
David, D-A-V-I-D, Joel, J-O-E-L, Jimenez, J like John, I, M like Mary, E, N like Nancy, E like Edward, Z like zebra.
Right, Dr. Jimenez, I want to just remind you of a couple things that are important. We have a court reporter here. She's taking down everything that's being said. So it's very important that you speak up nice and loud so she can hear you, and that you also speak slowly, particularly when you read from something, because when we read, we tend to speak a little faster than we normally do when we're speaking. So just please keep that in mind, because she has to do her job and we want to make it as easy as possible on her. The other thing to remember is that when you're being questioned by Mr. Tan and the board members, please wait until they finish the question completely before you answer it. That is because she cannot take down two people speaking at the same time. Also, if you have any objection to any of the questions that you're asked, please let me know. You must have a legal basis not to answer a question or have an objection to a question. But if you have an objection, I will get information from you and then I'll make a decision on whether or not you are required to answer that question. I know you were provided information concerning the structure of this hearing today and the time limits concerning the presentation of evidence. I believe that you are entitled to a half hour to present your case, and then we will open it up to questioning by Mr. Tan and the board members. All right?
I understand, Your Honor. Thank you.
All right, then. You may begin. All right, and does Mr. Tan have a copy as well?
He does not get ready to bring 11 sets. I presume one of those will be the set.
All right, I'm going to hand you one because he's entitled to a package as well.
Okay.
All right, before we get started, I'm going to mark the packet of documents that you provided for identification. And I'm going to collectively mark them as Exhibit B. I'm sorry, as Exhibit A, Petitioner's Exhibit A.
Of course, that's fine.
All right, Dr. Jimenez, you may begin.
If it pleases Your Honor, I'd like to walk through briefly Exhibit A, very briefly, and then present my opening statement. Thank you. Before you are actually 4 or 5 attachments. Basically, I made copies of these documents after reviewing the state's discovery CD because I thought a question might arise, and so in an abundance of caution, I decided to bring in this additional information. I'll walk through it fairly quickly. Your first page will say Addendum Number 1. It's stapled. It's basically refers to the typo. On page 1, there's an email to Mr. D.A.G. Tan, where I incorrectly used the name Dr. Crowley, and it should be Dr. Furukawa. Just a minor. I'm sorry. I had written Dr. Crowley, but the name should be Dr. Furukawa. Furukawa. WA. And then again, a typo on the probation report. On item number 16, I was referred to, this is AGO 0373. Again, just a typo, is referred to as Dr. McDowell. Just again for the record. The last 2 pages of this typed attachment are the 2 remaining checks that had not been cashed to the mother, by the mother, when I submitted my petition. She had, these checks were still outstanding, and so I just wanted to provide copies of the canceled checks. Addendum 2, it's the second stapled package. This is basically, when I reviewed the discovery by the state, there was a notation about the 59 score IQ, or rather, strike that, the CPLE score of 59 when I failed the test. And I simply wanted to offer that it was not a random request to consider a 59 as a passing score for that administration. In October 2015, the board had an initial passing cutoff score of 60, and then they rescored examinations and dropped that passing score to 59. So there was a precedent, and it's only to offer that my request was not in isolation of some event in the past. I was informed of that information by the CPLE test service that I utilized for preparing for the CPLE. Just a point of information. And the second page was simply my notes to myself about that. The third page, or fourth page, will be a listing of certified KSOB sex offender programs. This is the updated list. With my petition, I had sent in a March 2017 list, which was the newest publication. This is simply an update noting that I'm still on that official list with 2 certified site locations for the KSOB sex offender treatment program for parolees and probationers. During the approximate 2-month period between the time that I scored 59 and then passed the CPLEE, I was not allowed to perform any psychological work per se. I well understood that. I brought in a licensed, or rather a intern, operating under an MFT license, who would be Sandra Baca. And prior to that, I prepared a memorandum of understanding that that person would come in, do my groups. I would only be the administrator, and you have that memo, the memorandum of understanding before you, as well as their BBS license documents. Again, only to illustrate that I've conformed with all standards. The third package are simply a listing of 8 checks written to About Face, which was the corporation that allowed the use of their intern. And again, simply for purposes of documentation of the record, they are submitted. The last 2 pages actually relate and back to the complainant in my complaint. They are taken from, and it's a matter of public information. I downloaded these yesterday from the internet. It's from a newspaper called The Oklahoman in Oklahoma City, and it refers to the complainant who was arrested in 1980 after he was caught wearing gloves and tape recording secretly a licensed psychologist. He was subsequently arrested, prosecuted, and convicted. Subsequent to that, he was allowed to leave the state of Oklahoma, come to California, where he became a practicing attorney. It, as I view it, simply demonstrates a pattern of disdain for licensed psychologists. I've been the second one, but again, point of information. I'd like to read my opening statement, if I may.
Just please remember to speak a little slower when you read.
I'm sorry.
And
I do apologize.
just maybe if you could just bring the microphone up to you a little closer, that way you don't.
Is that
I think that will be helpful.
better for you? All right, just flag me if I lose you. All right, may I begin with my opening statement?
You may.
Thank you. I do want to reiterate that this process for me and for yourselves has been 7 years. I've always viewed the board as my consultants in this matter, and that has been my state of mind throughout the process. David J. Jimenez, EDD, license number PSY 10629. Opening statement to the Board of Psychology, State of California. I relocated to Los Angeles, California on September 24th, 1984 from Phoenix, Arizona, and began full-time employment at Gateways Hospital and Mental Health Center, Los Angeles, California. I accumulated additional postdoctoral hours leading to licensure with the Board of Psychology after certain postdoctoral hours were determined not to be eligible from Bloomington, Indiana, arising from gaps in supervisor availability at one training site, i.e. the Center for Human Growth. Since September 24th, 1984, until the time that the accusation was filed in December 2012, I had no complaints filed against my license with the Board of Psychology. From the date of the accusation until the date of this petition filing, I have not had another complaint filed. This after having worked in psychiatric settings with high-risk individuals and in specialized clinical and forensic practice areas with high risk for patient complaints. Specifically, child and adolescent residential treatment programs with the Los Angeles Department of Mental Health, contract county providers, a child and adolescent mental health treatment center in a low SES area of East Los Angeles, and in private practice with high visibility and professional exposure as a child custody evaluator. This complaint is the only complaint that has been filed against my license with the Board of Psychology following administration of adolescent residential treatment programs, a child and adolescent mental health center in a low-income area of East Los Angeles, clinical and/or forensic evaluation of an estimated 2,000 children, adolescents, and adults, including forensic evaluation of over 400 pretrial adult sex offender defendants, some of who were Spanish-speaking, charged with California Penal Code crimes, and the conducting of an estimated 70 full and 8 solution-focused child custody evaluations in Southern California. My 3-year probation period results from a stipulated settlement and disciplinary order, order number 1F 2010-211-945 OAH, number 201-207-0262, before the Board of Psychology, Department of Consumer Affairs, State of California, ordered October 19, 2015, with an effective date of November 18, 2015. I did make procedural errors, and I did commit errors in judgment, which will be discussed in other sections of this petition. Throughout my opening statement and throughout the petition, you will note larger numbers in the right column, which refer back to my document listing, the exhibit listing, for your reference.
Dr. Jimenez, I just want to remind you about my statement earlier, which is the documents in your petition package the board has the benefit of, including
Right.
your opening statement and any of those documents. So your time may better be spent rather than reading verbatim your opening statement, and just start highlighting for the board the efforts you've undertaken to comply with the terms of your probation and the rehabilitation efforts you've undertaken since that time.
Right, Your Honor. As the documents stand for themselves, I trust that the board has had time to read the 592 pages and review these pages. I stand by my statements and representations completely in these documents. I have satisfied all the conditions placed on me and restrictions, and I fulfilled all restrictions ahead of time and ahead of schedule. And I would argue that my monitor would reinforce that statement with his own report, which is part of the document package. I'm open to questions from the board at this point in time because, again, the documents, I stand by all the statements in here and representations and what I've done in terms of rehabilitation and my errors that I did commit during this very complicated procedure, which, at the end of which I had a 4,207-page clinical file on the case. Typically, I'll have, as an evaluator, maybe 200 or 300 pages. It was extremely complex. These evaluations are fluid, and as I marked in my petition, I had a limited time frame for completing 2 evaluations. I will underscore that I never agreed to serve as a special master. I know that is the underpinning complaint in the accusation, and upon query from the DAG, I'm happy to report, to the best of my recollection, my state of mind as to what the questions you might have.
All right, as I explained, I'll have Mr. Tan ask you some questions, and then we'll open it up to the board members. And then if you have anything that you recall based on those questions or anything additional you want to add at the end, you'll have an opportunity to do so.
Thank you.
Mr. Tan.
Thank you, Your Honor. Mr. Jimenez, as part of this petition, you do admit to the allegations in the accusation, correct?
I do not. I admit the settlement is based on the 4th cause of action.
Okay.
Only. Initially, the accusation had 4 causes of action. And if you look at the settlement, I agreed to the 4th cause after this long period of negotiation because it was true. I did ask for certain safety factors to be put in place, and I can elaborate on those, but it's the 4th cause of action.
Okay. Could you elaborate on the portions that you do admit? I mean, I can turn to page AGO 366.
Okay, by way of reference, the 4th cause of discipline for discipline is AGO 0371. Right. What page number, I'm sorry, Mr. Tan?
I'm at AGO 366. There's a long list of allegations here that form 1, 2, and 3 and 4th causes of action. Do you know which particular allegations here you do admit? Just so that we know.
I find the question overly broad, Mr. Tan.
All right. So, Mr. Tan, if you could narrow your
I
question,
can do that, yeah.
please. Thank
Do you admit that you failed to obtain consent from mother and father for respondent to make for example, on August 19, 2010, a written recommendation solely at mother's request, in which you cited Penal Code 273, you strongly discouraged father from taking JA on a boat trip, despite despite you not knowing anything about father's skills as a boat operator.
May I respond?
Yes, I'm asking if
May I
you
respond?
do admit that portion.
I don't admit to the language used. The state of affairs was, in fact, that father had told me, and I have a photograph of the boat in question, that he intended to take his 13-year-old autistic child to Catalina, which is 26 miles across the ocean, in an open 15-foot boat, which is called a Boston whaler. I have a photograph of that in my report, if you would like to see it. prior to having him reconsider his decision. The boy had already jumped out of the boat once, I was told by the mother. I had contacted the harbor master, the Marina del Rey, Los Angeles harbor master, inquiring as to what size boat might be required to make that ocean crossing. I was told it was no smaller than a 25-foot boat with a ship-to-shore radio, a plan known by someone on land. I then further contacted the U.S. Coast Guard, who spoke with their sea rescue experts, and I was given the same information. It had to be no less than a 15-foot boat with safety precautions, etc., ship-to-shore radio. Upon receiving that information, I encouraged Father to think twice about making such a trip.
Okay. What about letter C? That you recommended that the frequency of J.A.'s visit with his psychiatrist be increased without consulting J.A.'s psychiatrist?
Under I don't know if it's changed now, but under Court Rule 5.225, a child custody evaluator may make interim recommendations during the course of an evaluation. I don't need a parent or a litigant's permission to make interim recommendations. Both parents in this case were represented by counsel, and so again, I did make certain recommendations during the course of the evaluation, one being that the child, rather than being seen once a month, have those visits moved up to psychiatry to be twice a month, based in large part on the great difficulty he was having both in school and at home relative to behavioral issues.
What about letter E, that you accepted a partial payment from mother, a check from mother's second husband drawn on a Wachovia bank account, despite the express payment terms outlined in your engagement letter that all future interim and final payments must be made by Chase Bank, cashier's checks payable to custody care, and requiring that all of father's payments be made by Chase Bank. Do you admit to that?
I recognize the language relative to Chase Bank cashier's checks because that is part of my retainer agreement. I don't recall, well, it may be true, that I accepted a bank check from other than a Chase Bank. However, the payment that we're discussing, November 1, I believe, well, my point is that I submitted my reports to the court with copies to both counsel at the same time in Orange County, even though the parents had owed me still a great deal of money on the case. I don't recall that particular Wachovia bank. This would have been her new husband.
Do you admit that on November 1, 2010, you sent an ex parte communication by email to mother and mother's attorney?
Relative to item F and item G, they're both the same accusation. While I'm 69 years old, at that time I would have been 62, I did not know, and I'm my own secretary, that I could send an email to more than one person. So I'm sure what happened is that I sent an email and then copied it and then readdressed it to the other attorney and or parent. That is what I believe happened. And again, it's due to my lack of IT knowledge. I'm sure it's very possible I did that. It was not ex parte communications. I understand ex parte, but I didn't know I could send it multiple people. I do now. Multiple people the same transmission.
I'll move ahead to the next page. Letter M, that you told father and mother's attorney during a conference call that it was your opinion that father's thinking was linear and one-dimensional, and that father's parenting style was comparable to playing checkers, while mother's parenting style was comparable to playing chess.
I did make that statement, and it was in a greater context. Certainly, my understanding of each of those parents at that point was that father was very deliberate and very probing, And so while he would ask a question, he knew the depth of his question. He would go layer by layer by layer. Mother had a much more scattered approach to answering a question, and that's what I meant by again playing chess. She didn't have. They're very different personalities, and they're very different people, and they answered questions in very different ways. It was not meant in any way to demean one parent over another or compare parents, but simply the fact that father is very very complete in his investigation. When he starts to look at something and ask something, there are many layers to it. Mother is more global in her approach. So again, it was my statement. It simply was taken out of context in a larger discussion on a conference call with both counsel.
Moving on to letter T, AGO, page 0369, paragraph T, that on December 2010, the same date that you appeared at an ex parte hearing in connection with father's motion requesting your removal as child custody evaluator, the full hearing of which was set for January 21, 2011, you chose to begin performing the bulk of your activities on the evaluation, begin preparation of your final evaluation report with a final bill totaling $42,000, and complete your evaluation and submit your report to the court prior to the January 21, 2011 removal hearing.
That is an incomplete and inaccurate representation of the facts as I know them to be. On December 20th, the father's attorney, Barbara Hammers, went in for an ex parte hearing to have me removed from the case. This followed a day or two of a blitzkrieg of emails from her and from father asking me to recuse myself from the case. I did not know, having done all this court work previously since 1991 as an evaluator, that I had an option to step off a case once I accepted the appointment. I believe that to do so, as I stay in my petition, would be cause for a complaint, be it malpractice or some other complaint. I did appear at that hearing. I was not allowed to be heard because I was not a party to the action or the case. I simply was there in case the judge wanted to ask me a question. And Clay Smith, the hearing officer, did not. It's incorrect to say that I began preparation of the final report at that time. This is a child custody evaluation which goes, I want to say about 106 or 7 pages. It's extremely extensive and complicated. My process, if I may, is that I will interview individuals in the case. I will then transfer those notes onto a flash drive. I then will edit that flash drive, and my report becomes cumulative through time. I only had a few remaining activities to do on December 20th of 2010, so that would be an incorrect statement. I don't know about the 42,000 number. I think that's an overreach. And again, my entire intention was to have the report, and court rules require the report, a child custody evaluation, unless it's a solution focused, to be in the court's hands 10 days prior to the court hearing. That was my mandate and my mantra. I've always made best efforts to have that occur so as parties don't incur additional attorney costs or aggravation or inconvenience.
So, just to clarify, you did not know that you could withdraw as the child custody evaluator despite the fact that there was a pending removal proceeding against you?
That's correct. At that point in time, initially I began doing child custody evaluations with a group in Los Angeles that was the only sanctioned group in 1991 to do child custody evaluations through the court That's the LA Superior Court. There were about 8 or 9, 10 of us who were private practitioners. And Lionel Margolin, who's now deceased, headed up that panel. We had a physical office in the court building at 111 North Hill Street. I was brand new. It was a learning curve. And throughout, until 2002, when the Superior Court drew up their own panel of experts for child custody evaluations, we were the group that was mandated to address evaluations that were complex, as it were, because only about 3% of child custody litigation goes into an evaluation. They tend to be the more complicated ones, or more litigious, if I say. So it's true to say I did not know, and I had not, and I go to, in all those years, there's a 12-hour required training every year to maintain your child custody credentials as an evaluator. I'd never met anyone of my colleagues who had withdrawn from an evaluation. I didn't know you could. I didn't know one could withdraw. So yes, it is a true statement that I did not know.
So, despite the fact that there was a pending removal proceeding against you, you did not know that you could withdraw as a child custody evaluator, and instead of waiting for that proceeding and giving it due course, you decided to expedite your findings, correct? And beat or preempt the removal proceeding? Would that be accurate?
No.
You didn't choose to preempt the removal proceeding against you, Doctor?
If I may, Mr. Khan?
That was the question.
No, I did not. There was not a proceeding. There was a hearing. The father's attorney had come in ex parte and requested a hearing to have me removed as the evaluator. I call that a hearing, not a proceeding that was active. At the end of that hearing, the judge did not remove me from that evaluation or my work, and I completed my work under court order. That judge went on about 2 years later to become the presiding judge in family law for the Orange County Superior Court. And at that point in time, even though I was on probation, it invited me to come back and reapply to be on the family law evaluation panel for Orange County Superior Court. His name is Clay Smith.
What about paragraph W? In a January 4 letter, you stated that you would release your final report to father and mother only upon receipt of full payment of your bill?
On or about January 4th, again, I had written both attorneys indicating that the parties had not made final payment for the evaluation, that payment fee structure and agreement is part of my retainer agreement, which is multi-pages, maybe 6 or 7 at the time, that lays out procedure and due process and fees and payment, etc. And so, again, as I mentioned earlier, the court hearing was to be held for receipt of my evaluation on January 21st, 2011. I was trying to get some payment in prior to my handing over the report. I would not ever hold my custody report at ransom, as it were. And so I did personally deliver the court's copy of the evaluation and a copy for each attorney, which is protocol, to the clerk of Judge Clay Smith's department, presumably on that day, 10 days prior to the hearing date. It might have been on that day, because I think I even made mention, if that's the letter, that I would be in the lobby to receive payment if they had payment. But not having payment, I still delivered my work product to the court and the attorneys, so again, no one would be inconvenienced. Now, payment is, sometimes we're paid, sometimes we're not paid. It's not the end of the world.
Letter V, on December 30th, 2010, he wrote a letter to father's attorney informing her that any further communication from father would be interpreted as an attempt to interfere with and delay the evaluation, although you place no such limitation on further communications with mother, and in fact conducted an individual interview with mother that same day.
May I have your notation? What number are you on? I'm sorry, Mr.
Letter V for victory. AGO 369.
V for victory. Oh, I see. Give me a moment to read this. Yes. In the days leading up to, again, this was the December 30th letter, on or about, beginning about the 15th, I would say, of December. I had, again, a deluge of, well, 2 or 3 requests by the father to recuse myself. These were text messages. They were not, I don't recall phone calls. The same from the father's attorney asking me to step off the case. Again, I did not know I had that option. I think one of the issues had been that father was and had been under the care of a psychiatrist for 5 years. He had initially authorized the release of those records to me, and then in that month retracted that release. 5 years of psychiatric records are very important to an evaluator. I found, I believe that they could be important and helpful and informative to the process, as well as to provide more information about his compliance with whatever the psychiatrist might have recommended, how he was doing in treatment, etc. I thought the records were important, but that was going on about the time. Mother and mother's attorney they were simply responding to my request, maybe for a meeting or a meeting with the new father's adult daughter, who I think worked for one of the phone companies at the time. She lived in the house, and it was important to see her as a collateral, I believed, which I did ultimately do. So there was that pressure, and I was, again, trying to finalize this report on this very complicated case, and to be interrupted, strike that, to be taken away from my conceptualization of what I thought the issues were and how to best address the issues before the court, caused me some delay. I also canceled a holiday trip to Texas, where I'm a native of Texas, in order to complete the work in a proper fashion.
Right. Mr. Tan, it's 10:27. This matter is set to conclude at 11. I want to make sure that the board members have ample opportunity to ask questions. So if you could please focus your questions, and
Yes, Your Honor.
With the anticipation that you will finish in the next few minutes.
Okay. What about paragraph 25 on page AGO 370? That during the course of the evaluation, you requested and obtained a complete copy of J.A.'s treatment records with his psychiatrist, and that following completion of that evaluation, you produced to mother and father a complete copy of this file, including J.A.'s psychiatric records, making no effort or provision to protect the confidentiality. As a direct result of this breach of confidentiality, J.A.'s psychiatrist, after 2.5 years of treatment, resigned as J.A. psychiatrist.
May I respond?
Sure, absolutely.
Yes. The primary reason that it took 4 years and 10 months to negotiate out a settlement with the board was in large part to the inaccuracy of these accusations. Point in fact, relative to the psychiatric records, the parties had agreed to, because they shared legal custody, agreed to allow me to talk with Dr. Sin, who was a psychiatrist at the time, and to review records and get copies of records. I did obtain copies of records early on in the case. Those records became part of my file in a separate package. I was always in custody of those records. What happened, in fact, counter to what the allegation 25 is, father's attorney went into the court and demanded a subpoena to copy my entire file. The copy service that was granted by the court and Judge Smith. The copy service came into my office on a selected day and spent 2 8-hour days with 2 people copying my records while I maintained custody of the record visually for the entire 2 days. I never charged for that time. I was happy to facilitate the court's request. When they took their machines out of my office, complained the office was too small to even make copies, but they put them all on, I take it, a CD. When they made those copies under that court's order for release of records in my complete file, I lost custody of those records. I had no control over the dissemination, distribution, or review of those records by anyone once that copy service fulfilled the court's order for production of records.
Thank you. Could you please turn to AGO 12 of your petition? That's Exhibit 1, AGO 12.
Yes. Oh, HO 12, I'm sorry. For some reason, I jumped from 5 to 14.
Do you
Am
have
I-
a bad copy?
I jumped I'd never changed the order of these pages, and I jumped from AGO 6 to AGO 14.
And Mr. Tan, my copy is the same.
Your Honor, it looks like we have a bad copy service. Do all members of the board have page 12, Your Honor?
So we go from page 6 to page 14.
I see, Your Honor. It looks like there was an error in photocopying, Your Honor, but if I may,
Your Honor, I would request not being able to, or not having to address a document that I don't have before me and I didn't have time to review and prepare for.
Your Honor, if I may, Your Honor, this is your petition.
That's one page of many pages submitted.
That is the petition that you filled out, Doctor?
I'm looking at AGO 0012, but on many of these pages, I will refer to attached pages.
All right, we're just going to allow Mr. Tan to take a look at the documents, pull them out for you. If they're in fact documents that you submitted,
Yes.
I would assume that you have seen them before. And what we will do is make sure that the board members and then I receive a copy of those missing pages.
Yes.
Doctor, isn't it true that this is part of your petition? It's page 10 of your petition?
Yes, it is. 10 of 25.
Your Honor, seeing that there are no other extra pages, Your Honor, then I'd have to suggest something unconventional and actually go through with each member of the board what the page looks like.
I have them. You know what, it's not where after this one, and then it goes to 7, 8, 9, 12, and then it goes back to.
All right. I see that. So ours is just out of order, that's all. We have the pages.
You do have the pages.
They're out of order, yes, and that's the confusion. All right, thank you. Thank you for the clarification.
Okay.
So it would be page 10 of your petition, Doctor. So if you could just find.
I have page 10,
Oh, there we go.
Mr. Tan.
AGO 12. There we go.
Yes, right.
So, Your Honor, we're on AGO 12.
Yes, we're there. Thank you.
On box number 1, you were asked, and you filled in this application. It states, describe the events that led to the discipline. For reinstatement of license, does your decision require you to admit all or some of the charges in the accusation filed against you upon petitioning for reinstatement? You checked yes.
Yes.
What specifically were you admitting to?
The fourth cause of action.
What is the fourth cause of action? What is your understanding of the fourth cause of action?
Repeated acts of negligence without referring to the actual document. Not gross negligence, which is another cause of action.
Okay. Do you know what constituted these repeated acts of negligence?
You've questioned me in the last 15 minutes about several of these.
Okay.
items
Okay.
within reference to repeated acts of negligence, Mr. Pan.
So I am a bit confused. Do you admit to it or not?
I admit to certain of the accusations
Okay.
contained within the accusation document, not to all of them. I certainly can provide responses to any other accusation within that section if you so wish.
All right, and Mr. Tan, as I mentioned, we're now at 10:35, so if you would please wrap up your questioning so that the board members have an opportunity also to question Dr. Jimenez.
Your Honor, I have nothing further, Your Honor.
All right, then. Now opening the questioning up to our board members, starting to my right with Dr. Phillips.
Good morning, Dr. Jimenez.
Good morning.
What did you do wrong?
What did I do wrong? I did, in retrospect, I made several errors. And as you read my petition, I found the educational review very instructive because it caused me to review my history of psychology since 1984 as accumulating hours and licensure, et cetera, and all my experiences. I discovered that I have an inherent bias toward protecting people, primarily children. And that flows out of when I went in private practice in 1991 in Los Angeles, I was already on the child custody evaluation panel, but I was an overflow evaluator, didn't get much work there or assignment, but I was on I'm sorry, how far back would you like me to go? Right. In 1991, I was accepted. I applied to and was accepted for the dependency court expert panel with LA Superior Court. 2 years later, I went on to again by invitation, juvenile court expert panel, and then other various expert panels within Southern California: Riverside adult, Ventura adult, Orange County criminal, Orange County family law. It's to say, I don't want to ramble, but it's to say that I spent the first 15 years of my career in California protecting children, be it in treatment, in residential treatment, or elsewhere, for the courts through evaluation.
What did you do wrong?
I allowed that bias to interfere with my objectivity.
Did you do anything else wrong?
I'm sure I did. I was not sensitive enough to the father's parenting abilities and skills. I should never have accepted. When I accepted the appointment orally, I was driving. There was a conference call between both attorneys. They said, "We'll send you the court order." It took 5 weeks. I was under a time frame to produce a school choice evaluation because the parents could not agree on which school. Father had sued and won a settlement from the school he preferred the child go to at that point. The mother wanted one in her home district, which is a different city, and had more resources economically, financially, and resource-wise. And so it took me, because of the rush to get the school evaluation finished, which would have been 1 month in time to have the child enrolled, I didn't wait for the written order to come in. When it finally came in 5 weeks later, it was so illegible I couldn't understand it. In the conference call, they wanted a special master on the case, and I told very clearly counsel that I believe that a special master at the same time as an evaluator on the case would contaminate my evaluation data. And I preferred that special master wait until my evaluation was completed. That was a major error on my part. I should not have accepted it as a bifurcated evaluation. As I mentioned also in the petition, in my responses, once I did the school evaluation, I failed to recognize that whatever parent school I did not select, I could possibly be viewed as prejudiced against or biased against. And I clearly understand that now and later in time. So yes, I did make mistakes.
I want you to turn to, if you would please, AGO 17.
Yes?
Item number 3, where the first sentence is, my license was not disciplined as a result of any inappropriate behavior or conduct.
Yes, I made that statement because in reading, essentially, I misunderstood. Well, at the last board meeting, I was able to, through the webcast, watch 3 petitioners come before the board. In looking at the documents, there were certain documents that were meant for completion by someone who perhaps had been arrested for a DUI or some sort of criminal offense, leading to that conduct leading to some criminal offense. That's how I answered the question. So I misunderstood. I will say, my conduct wasn't. When I say my license was not disciplined as a result of any inappropriate behavior or conduct, I took it to mean that I committed some criminal offense, like a prior DUI defendant who met with this board at the last board meeting, and she had had 2 DUIs, and that's how I misunderstood my response. Does that make sense to you?
Kind of.
Or drug use, etc., or alcohol use, something that would have impaired my judgment.
You understood when you entered into the settlement agreement that you were agreeing that you had done certain improper actions, correct?
Yes, I admitted to the 4th cause of action. Yes, sir.
And do you understand what it means to be rehabilitated?
Absolutely.
And what does it mean to be rehabilitated?
That one reviews their course of action and makes improvements so as to not ever fall within some accusation in the future.
You feel like you're taking responsibility?
Absolutely.
Okay.
Yes.
Just so I understand, in this case, you assumed 3 different roles, the child custody case. You did the educational evaluation, you did the child custody evaluation, and you also acted as special master.
May I respond? An evaluator can perform an educational evaluation. It's a school choice evaluation, all within the umbrella of child custody evaluation. One can do a full evaluation. That was not a role conflict.
You don't believe there was a role conflict between doing an educational evaluation and a child custody evaluation?
In retrospect, yes, but it's been done many, many times in LA County.
Does that make it okay?
No, but one speaks to peers and court orders, the court ordered that, and I won't presuppose what the court was thinking, but the attorneys were in line with having a school evaluation choice done, and then the full evaluation. I never assumed the role of special master.
Are the attorneys in the court responsible for your ethical?
No, they're not. No, sir.
Okay.
It's within me to know that. I'm sorry.
Right, please.
I apologize.
Dr. Jimenez, please wait until Dr. Phillips finishes
Yes.
the question before you answer. As I mentioned,
That's fine.
The court reporter can't take down 2 people talking at the
Me
same
too.
time.
I apologize.
Yes. And the question was again?
Are the attorneys and the judge responsible for your ethical responsibilities?
No.
Okay. You gave us 3 letters of character reference speaking to your rehabilitation. Is that correct?
4 letters.
4 letters? Were any of those letters written by psychologists?
No, there were not.
You indicated that you consult with people in different states even regarding matters that you're working on. Is that right?
The letters are framed by people I've known throughout the years in my career.
Are they people you regularly consult with?
Very informally.
Are there psychologists you regularly consult with about your ethical responsibilities?
Yes.
Okay. Why don't we see a letter from one of them?
Because, as I mentioned, we're all in private practice. We all know well. 7 years ago, it would be a case that sometimes you might get a prior evaluation done by one of your peers. We wouldn't discuss that with that peer. It might just come in as part of a submitted document. It's not a group that lends itself to coming together to discuss mutual issues. It's very competitive. We're all private custody evaluators. We know each other's work by virtue of being around so many years.
So in other words, if you have an ethical question about a child custody evaluation you're working on, you do not consult with other psychologists.
That would not be true. I would call Mr. Harris, Eric Harris, at my malpractice provider, and I've done it numerous times.
Is he a forensic evaluator?
He is both an attorney and a psychologist.
Okay.
I don't know if he does forensics.
Okay. Do you have a collegial circle of psychologists that you consult with?
I do.
Okay. And just so I understand, none of them are willing to write a letter?
I never asked any of them. I never invited any of them to write a letter. Not that they were not willing to write a letter. Barry Hirsch is someone I've known for the last 30 years. He's a forensic psychologist. Other people I could name, but we don't typically. We may call each other, and we have many. In those days, we have many meetings with it. Family law always had trainings, not so much in criminal. In criminal, you're more isolated, but in family law, you would see someone at a meeting. They might discuss something in a hypothetical. You would not offer your thoughts.
Okay, can we go to AGO 325? And then I will stop because I know other people have questions. I'm sorry I'm taking so much time.
And if I may also consult informally my former spouse, who is a psychologist in Los Angeles.
Actually, I think it may be AGO 321. I misspoke.
321?
I believe that's your resume.
Yes.
Okay, and is that your current resume?
It was current at the time that I submitted this petition.
Okay, and if you go down to the description of the different types of services you provide, the second to the last line from the bottom, you say you do attachment and bonding studies and family reunification evaluations?
Yes?
You don't consider those to be child custody evaluations?
No, those are dependency court-related evaluations.
Okay, but they do impact the custody of children, is that correct?
They may ultimately, that's up to the trier of fact, but those are they're requested fairly often through dependency court through many years ago. I haven't done dependency work for many, many years, but I occasionally will get a case from the court.
I have no further questions at this time.
Thank you, Judge. Good morning, Dr. Jimenez. I had a couple of questions, and
Of course.
I want to come back to that line that was referenced by Dr. Phillips about my license was not disciplined as a result of inappropriate behavior or conduct. In your follow-up to his questioning about that comment and about bias, you said that you were possibly biased against the father, but when the DAG asked the same question, when Mr. Tan asked that question to you, you said there was no comparison, there was no bias at all in some of those items that he listed and read. Is that correct?
In retrospect, and going back through the case these many years, as you go through an evaluation, you come in, you initially enter the evaluation as tabula rasa. You're a clean slate. People are a clean slate. As you go through an evaluation, you get to know the individuals involved who are parenting. We are not perfect. Some people do some things better than others. One parent might be stronger in A and B. Another parent may be stronger in C and D. You look at the combination of what each parent brings to the table to present and formulate a parenting plan for the future going forward for the family. And it would be true to say that at the end of the evaluation, my ideas about a parent's parenting skills might be different than at the beginning.
I guess my question really is, you told Dr. Phillips that yes, you did have bias, but when you answered those questions earlier from the DAG, you said you were not. So I just wanted to make sure, as you think about it more, do you feel like, yes, I was biased? Because I'm a little unclear as this hearing has gone along.
Toward the end of the evaluation, I had bias toward father in terms of his parenting decisions, not in terms of him, but the decisions he would make. For example, And these are listed in some of the accusations that we didn't discuss. But for example, and I have a photograph of the knife, he allowed his son to go to the mother's house, because the child would go between mother and father's homes with a survival tactical knife with a blade that was 3 inches plus long, locking type blade. It's described as a tactical survival knife. We talked about he had a knife collection. I counted 24 knives. He kept them in a rubber Tupperware container, about maybe 18 inches wide by 2 feet long, 1.5 feet long maybe. They were secured, they were unsecured in a closet in a hallway when I was there during a home visit. Many were very sharp. The child was I don't know him now, I've not seen him for 7 years, was very impulsive. This is a child who would climb up on the father's roof and urinate off the roof during the night. He would urinate in bottles at the mother's house and then throw the bottles out the windows. He would had shot either a neighbor's leg or the neighbor's car with a pellet gun, a BB gun. He was extremely impulsive. And so, yes, I certainly reached an opinion about father's limited parenting skills and how to better address those with him.
Okay, let me ask 2 more questions. I guess you said earlier when you first began your comments, you made a comment that you viewed the board as a consultant in this matter. What does that actually mean?
It means that for me, that whatever I do, although I've been licensed in 1988 in California, I can do better. I'm open to any recommendations. I was happy to take the ethics courses. I certainly have learned things through taking the CPLEE that have changed over time since I was licensed. Clearly I'm not going to do child custody evaluation anymore. I've timed out, whereby court rules 5.225 require you to have done 4 within a 3-year period before you can be appointed to the next one. It's not my interest any longer. My interest is strictly within criminal. What have I learned? I've learned, again, I think I learned every day from colleagues. I learned from patients. I learned from the sex offenders I meet with weekly. It's a dark topic, but I've learned how to do my work with more thoroughness every time. I think I'm pretty thorough, but I can always improve on what I do.
And finally, based upon what you answered at the last comment about that statement about you not feeling as though your license was disciplined as a result of inappropriate behavior, you said you think you answered it wrong. Hearing kind of the whole discussion this morning, do you feel like that's a correct statement in your document now? Do you feel like you did do something?
If you term conduct, if you apply conduct to my saying to father, you might reconsider your trip to Catalina across 25 miles and ocean shipping lanes in that boat. And by the way, in 2015, someone with the same boat drowned in the harbor at Ventura. I have that newspaper article. Same boat. If you consider conduct within my saying, you might reconsider that trip. You might help me understand how your son got to the mother's house with this knife. If you consider that conduct, yes, then I'm guilty of that conduct, of asking the questions. Because ultimately, my role at the end of the day is to keep my role at the end of the day, as I see it, is to keep everybody first alive and safe. And I will ask, and I did ask questions, and if that was erroneous or wrong, I certainly admit to that.
Any additional questions?
Child custody evaluation is extremely emotional and volatile for many people. In Los Angeles, not too many years ago, there was a set of litigants, and the father shot and killed the mother in the courtroom on an escalator.
Dr. Jimenez, there's no question pending.
I'm sorry.
Hello, Dr. Jimenez. I have a couple of questions. I'm still trying to get clear how you understand what it is that you did wrong, and whether you could put that into a phrase or two, and then if you could explain or demonstrate to us how you have met the burden of rehabilitation for that wrong, and why you think, I guess this is a three-part question, why you think early termination of probation is warranted in this case.
The first part, what did I do wrong? I took on certain actions, made certain statements to the father that could clearly have been interpreted as my operating as a special master. I chose certain language, as I mentioned in my petition, that was stronger than may have been needed. Word choices. I have taken every opportunity to take ethics courses in this probationary period. They're on record. I've done independent reading on ethics. I've signed up for new independent study on ethics. I've learned and relearned some of the same information I knew to be true. I have, relative to my burden of proof, I've come before you. I've met voluntarily and at request of 2 different probation monitors. I've fulfilled every requirement early, as it were, ahead of schedule. I've paid all fees, which was a $75 cost to the board, presumably for review of my work and that work product. I've provided over $24,000 in restitution to the parents across the last, I want to say, almost 3 years. I'm here before you to be a better psychologist in any way possible.
One of the things you just said, why were the parents in need of restitution?
I'm sorry?
Why did the parents need to be why did they need to have some payment?
Well, the way that occurred, Mr. Erickson, is that my report went into the court on January 21st, 2011. Shortly after, the father deposed me, and I was in a 2-day deposition. The court made a ruling. In my child custody evaluation, one of my recommendations was to have both parents retain joint legal custody. And I offered, part of that parenting plan with caveats. The court, after reviewing my report, chose to give and award the mother full legal custody. The father, because he is an attorney, I presume, and had the legal ability to do this, then filed an appeal and went to the appellate court. The 4th, I believe it's the 4th district, I could be wrong. I did not know anything. Once I turn in a child evaluation report, I hear nothing unless I'm brought in as an expert witness. I got a phone call one day from someone who identified themselves as a reporter, and they wanted my opinion on the appellate court ruling. I knew nothing about this, and I declined to talk with the person. I then found out that the father had appealed the ruling that removed legal custody from him of the child, and he had gone up to the appellate court with these accusations that you have before you. The mother, who had significant financial resources, chose not to answer the appellate court or present any evidence to the appellate court in her behalf of her positions. I again, because I'm not a party, could offer nothing. It was already passed. I didn't know it was being appealed. So the appellate court then came down with an opinion in favor of father. Now, when you go back to court, the mother had, at different points in time, had represented herself in pro per, and other times brought in counsel. It depended on her issue or whatever was going in before the court, whatever the court's going to hear. But at the last hearing, which has to be somewhere around June, I could be wrong with the date, in 2011, they had, still when they were in Judge Clay Smith's courtroom, the mother had no allegation that I'm overcharged for the case. In fact, she had represented, she was very pleased with the process, with fees, had paid fees regularly, etc. At some point, after that, she had no attorney. She met with father's attorney. They had a discussion. I don't know what the merit of that discussion was. And the judge had said, you've had 3 or 4 times opportunities in my court to raise the question of fees and any allegation of overcharging for the work. What happened then is that the judge sent the case to a different courtroom. And in that courtroom, I did attend the hearing, but again, could not speak as I was not a party to the action. Both parents, well, father's attorney and mother in pro per, argued I'd overcharged. That court then allowed me to retain and keep $6,500 of the toward a school evaluation choice, the first evaluation. That number was determined because father brought in his own expert and said, well, that work is only worth $6,500. Then the court ordered me to repay the parties all the money I had collected on the case, except for the $6,500. And that led to my reimbursing mother about $14,800 and father $8,100 through the course of the next 3 years, more or less.
I mostly followed. There's quite a series of events here, but I think maybe the bottom line in my mind is you've done 2,000 some cases. How many of those have you been ordered to pay restitution?
None.
Except this one?
This is the only case, Your Honor. I mean,
No further
Mr.
questions.
Erickson, this is the only case. Over 2,000 cases in 5 California venues. Where I was doing child custody in Orange County and LA for many, many years. The rest were dependency court in this county, and then the rest were adult courts in 3 other counties. And I continued to work in York County for their Superior Court.
All right, additional questions?
Thank you.
Hi, Dr. Jimenez. I'm interested in your time during probation. Aside from the requirements from the board, what have you done specifically to prevent these acts of negligence that you admitted to committing?
Can you repeat the last part of your question, Ms. Kasuga? What have I done to prevent?
What have you done specifically to prevent the acts of negligence that you admitted to committing?
Okay. When the board complaint was made, that was the end of December 2010. In the next 2 years, while we were negotiating with the DAG's office, I only performed probably 2 more evaluations. The purpose of that was simply to stay in time with the requirements under the court rules 5.225, which required the 4 within 3 years, 4 evaluations to allow you to continue to be qualified to be appointed. I stopped voluntarily doing them before I was ordered to do child custody evaluations of my own accord. I proclaimed and represented that I had no more and further interest in doing these kind of evaluations. in my career. I love criminal. People seem to believe that I do very good work, as represented in some of your documents where in year 2014 and 2015, I averaged between 94 and 98 appointments per year in LA Superior Court. Now, that panel has about 95 people on it, and judges can pick and choose who they want on a case. But my following was such, and my reputation was such, even in probation, or prior to, even during the period that I was under the accusation. Okay, we hadn't reached a settlement yet. I was frequently used. Even as late as a couple of months ago when I did I did an evaluation on a criminal case in Orange County, and that attorney, Olga Giller, knew I was off the panel for many years, but got her private she wasn't private counsel, she's the public defender office to pay for my fees for that evaluation. Up until March of last year, I still was getting, and I list some, after once I signed the settlement order, that was in November, 2 years ago plus, there had been the hearing officer for the psychiatric psychological panel in Los Angeles was Ronald Rose. He was there before many years. He knew about the complaint. I updated him frequently about the complaint. He allowed me to work without restriction. He retired, and when he retired, a new judge named Judge Hanasona, I think I want to say, came in from a misdemeanor court. And I sent him a settlement agreement, which admitted that fourth cause of action. And I sent him the copies of the accusation, the settlement agreement, everything that he could possibly want to ask about. And he does have a committee. He met with his committee, and based on the committee and the letters here in the file, he did choose to suspend me, not terminate me, but suspend me from the panel pending, future outcome on this petition, as it were, in probation. From that time forward, I would get frequent phone calls from public defenders who wanted me to be appointed on a case, and I each time told them I could not accept a court appointment.
Dr. Jimenez, we are running out of time, and I think it's very important that you focus on the question that's being asked, which was, what have you done since you've been placed on probation to ensure that the conduct that you've admitted to, the negligent conduct you've admitted to, will not be repeated? So it's very important that you respond to that question so that we can make sure that the board members all have an opportunity to question you.
Thank you, Your Honor. I've again chosen, and I will not do child custody evaluation again. I've chosen to consult, with colleagues on various ethical dilemmas that I see coming up, perhaps in a case. I've done so again with one of the gentlemen who's a polygraph examiner, because certain ethical issues come up on patients that I might send him for evaluation through his polygraph, which is a state requirement. So it's talking with colleagues within the area, and again, my ex-wife, who is frequently available to me to discuss anything that may come up. It's a very fluid world, but ethics are ethics, and I have always adhered to, and I think the last point I want to make is I contacted my 4 referral letter submission people. I never told them what to say. I never asked for a copy of their letter. I simply told them, and they have a working idea about this whole probation period and just a very basic understanding of what brought me in here. And if you read the letters, I believe that they overlap relative to my integrity and my wish to be a better clinician.
Just one more question. I just wanted to follow up on Dr. Erickson's question, because I didn't get a sense that it was answered fully. Why do you think your probation should be terminated early?
I have I have the knowledge and the willingness to not repeat my past mistakes. My father always said, "You're going to make mistakes. Try to make new mistakes in your life." That's where I am. It's been a learning lesson. It's been educational and educative, actually. It's been humbling, but that's beside the point. I don't perceive myself as a victim in this at all. I have always tried to do whatever work I do in the best way possible, in the best interest of that client. I certainly foresee my doing criminal work for the next 10 years. Typically I'll go to jail. Sometimes people are free and they can come in the office. They're on bail, but it's not, I don't think I'll be confronted with the same issues. These are very complicated issues in these cases, and they're very fluid. And judgment, certainly my judgment, was clouded at times during this evaluation period. I could have made better decisions, used different words, better words, recognized that I could have stepped off a case. I didn't know I could step off a case. Once I was appointed, I thought there'd be a different, and the case was a catch-22 at every turn. If I had not made mention of the boat trip to Catalina, I could imagine the boat capsizing in the darkest day. And then I had the foreknowledge that he was going to take this trip. Where would I be? I'd have a different complaint of the same nature. The cases, the other 75 cases I've done that are child custody evaluations, they don't burn a candle to this case. In the case facts. So I submit. I am completely in your hands.
All right, additional questions?
Yes, I
Yes.
just wanted to ask Dr. Jimenez that when you mentioned about the boat, so you did your due diligence and researched about that particular boat going to Catalina and what it could cause and how unsafe it was, and you researched with the Coast Guard and all of that, what needed to be done in order if he was going to take the child in the boat.
I did, and I have a photograph of the father's boat in his driveway, if you'd like. I did that before speaking with the father about the boat trip.
I just wanted to compliment you on doing that. Literally, because, and I'm which is in conjunction with your wanting always to protect children. So I wanted to congratulate you on doing that above and beyond what you had to do. And my next question is this. You had mentioned about you did your own record keeping. Had you mentioned something about that in some areas?
I've only, since I started my private practice in 1991, I have been my own secretary. The exception is Jane Leonard, who is one of the 4 people that wrote letters. She has done my billing for criminal cases throughout my career, the last 20 years. Now, what makes her a little special is that she used to work, and I met her through my association with Dr. Barry Hirsch, who is another, I've mentioned him, forensic psychologist that we used to talk about frequently because we shared office space. I rented from him for a number of years. And so while Jane Leonard is not a psychologist, she has read thousands of reports and brings a naive eye, but an informed ear to cases, and has always been very helpful as an editor to my family law reports.
Okay, just let me kind of clarify that because I probably wasn't clear on that question in terms of your record keeping, in terms of your somewhat like an administrative assistant. Were you the primary person?
I was it.
You were it. Okay.
Yeah, that's why I referenced when we talked about the emails and not knowing how to put 2 people on an email.
Yes.
Back then, I didn't know you could do that.
And this is the last
Please.
question. And it's a yes or no or however you
Yes. No.
I noticed that you had mentioned about the fourth cause, and you had said that the fourth cause of action you agree upon. And
Certain of the accusations, yes, and I said that during one of the times that we met with the DAG and we're seeking a settlement.
in one or two words, could you name that, whatever it is in the that wrong or whatever the wrong was in the fourth cause that you agree upon? Could you name it? Could you describe it? Or could you give it a name, one or two words?
That I was overly directive to the father,
Overly say.
overly directive, that I was too forceful to the father when I saw or believed that his child was in imminent danger, like with knife, like with the boat.
Would you consider that wrong, being overly directive with a parent? What I'm trying to get at, like I think the other questions have asked, I just want to get a sense of if you could name the wrong that you have said that you agree with in the fourth cause. If you could just give me a one or two word answer, because I noticed that you said in working with your criminal cases, there was a wrong that you could feel and touch, a product. And I'm just trying to get at, in this particular instance, and I know it's highly nuanced, the negligence and all of that, could you just, I just want a sense of what you considered was the wrong in one or two words.
I believe in a short sentence, my wrong was in not clarifying the nature of the order when I first received it. Because it contained special master language, that I would become a special master. I thought at the end of the evaluation, I'll address that. They know I'm not going to be a special master. I'm not operating like, I didn't believe that I was working as a special, that was a mistake I should have caught at the front door.
Absolute last question. Why should we terminate your probation earlier? Just one or two words. Why? One sentence.
Because I've been more than compliant with the board's requests. I've learned from my experience where I will not repeat anything that could be raised as an allegation. I've done over 2,000 evaluations with one complaint in this case. I expect to continue doing work without any further complaints in my career.
Okay, thank you very much.
All right, any questions to my left?
So I'm aware of the time, and I really think I'm going to only ask one question. You said that the educational review was really the most helpful
Yes,
aspect of this whole process for you.
it was very timely for me, yes.
What did you learn from that educational review?
That I had a bias in terms of protecting children, and I'm risk aversive, and I have to go back to my my early years on the dependency court panel, where you are charged with evaluating adults who have children and then saying about ways to protect them, and if necessary. I learned that I had that bias. Further, that I have to protect myself against that bias. It's a tightrope.
I'm sorry, but when you say protect yourself against that bias, what do you mean?
Against erring on the side of overprotecting, being over vigilant. I think certainly I was. If this had been, if I had gone in and made unannounced visits, if I'd which I did one time with Father, if I'd gone in to recommend he walk through his house and check for any possible safety issues with his 13-year-old special needs child, within a dependency court case, this is part and parcel for a dependency court case. And taken into this.
I'm sorry again, but that's not what you were doing, right? You were doing a custody evaluation.
I was doing a custody evaluation, right. And within that framework, if there were, I believe there were times I felt that the child could be placed in imminent danger, and that led to the accusations.
Okay. It was the action you took, if I'm understanding you right, the actions you took because of your concern.
Yes.
And that having that bias is what you got out of that educational review.
Yes.
You have that bias. It impacts your, has impacted or did impact the way you conducted that child custody evaluation.
Yes. And as a backstory to that, I have in another lifetime, I have a degree in special education. I had, a fair familiarity with that population, which probably made me more so. In terms of erring on that side.
Okay, thanks.
This is forthright as I know my own process to be.
All right, Mr. Fu, any questions?
It's on the final act. Good morning, Dr. Jimenez.
Good morning, sir.
So I join my colleagues in trying to understand where you have an appreciation for the misconduct that occurred, and so I'm going to just ask a few questions related to that. So do you admit to the forced cause of action related to repeated negligence?
Yes.
And per the accusation, those repeated acts include paragraphs 19 through 25. Is that correct? And that's AGO 65, if you need it for reference.
I'm sorry, AGO
65.
I'm sorry, I'm trying to locate it. 6.5?
Yes.
Okay. Once again,
let me repeat the question. So if you look at the fourth accusation, it references for incorporation the circumstances of paragraphs 19 to 25 as an omission of the fourth cause of action. That's correct in AGO 65. Is that correct?
That's correct with explanation.
So inclusive of those paragraphs 19 to 25 in the accusation, that includes the ex parte communication and the disclosure of records of the minor to the parents. Is that correct?
I had earlier explained that the representations were not always accurate.
So when you signed the stipulated agreement according to those fourth cause of actions, you admitted to the circumstances to 19 to 25. Is that correct?
I did. Now, if I may, I was told by my malpractice attorneys during our...
Dr. Jimenez, I just want to advise you that you are not required to disclose any attorney-client privilege communication you had with counsel concerning your decision to enter into a stipulation. If you provide that testimony, you're waiving that privilege. So just so you are aware.
Right. I was led to believe that had we gone to trial, that the board of psychology could overrule an administrative judge, even if we prevailed.
And on several occasions today, you've mentioned that there were circumstances of you not knowing a particular rule or technology, for example. So you mentioned, or in your communications with your peers or with technology. Do you think, does not knowing mean it's an excuse for committing the act of wrong?
Ignorance of the law is never a defense. In this case, I was and am a one-person psychological office. When I had to, for example, early on, Ms. Tanner asked me to remove any language relative to custody evaluations when we first began, and I had to go to an IT person to have it done. I don't know how to do it. So Ms. Tanner advised me that I was to remove any reference to child custody evaluation as an area of expertise. Following the complaint, I went to an IT person to do that because I didn't have the skill.
Understood. Thank you. And then one final question, which is, you mentioned in your testimony today that you don't perceive yourself as a victim in this particular case. I'm curious to know then why you introduced this article about the complainant at the end about, and I think you used the phrase, he's gone after psychologists, if you don't feel that way.
I didn't say he went after psychologists. It for me, points out to a pattern of at least dislike of licensed psychologists. I happen to...
Sorry.
I'm sorry?
I apologize for over... Does that dislike of psychologists excuse any misconduct you've done?
No. No. No.
Thank you.
I mean, to his credit, he came out here, he went to law school, he passed the bar, and seemingly does well. To his credit.
Right.
He's a bright individual.
Any further questions from our board members?
Yes. I just want to go back to the comment about, I guess, several people have asked about why we should terminate your probation earlier, and I want to go back to the comment that was made when the DAG was talking to you about the fact that actually, because your failure to pass the complete exam actually extends it out. So, and you wanted us to consider waiving it because you're 1 point below. Can you talk a little bit more about that?
Yeah, right. I had taken the CPLE. I missed the cutoff by 1 point. And I remember her name was Livonia. I forget her last name, but I did call up. I don't remember the name of the company that I used, but they send you a package or materials to prepare for the CPLE, and they said that there had been a precedent where in October 15, passing score had been 60, and then it was rescored and dropped to a 59, which was at 1 point. And I was simply raising the question as to whether that could be an argument for a 59 being a passing score. I was told no. I retook it, passed it, and we're here.
All right. Mr. Tan, with regards to Exhibit A, the additional documents that Dr. Jimenez provided to the board members, any objection?
No objection, Your Honor.
Exhibit A is admitted. All right. Any, please, just very brief closing remarks. And we'll start with Dr. Jimenez, unless Mr. Tan, you had something further.
I do, Your Honor.
Very briefly, we are about a half hour past our allotted time on this. So.
Absolutely, Your Honor. The hallmark of a petition for early termination is rehabilitation. And as part of rehabilitation, you have to admit what you did wrong. I think we tried to ask Dr. Jimenez 4-5 separate ways what he did wrong, and we don't know. I walked him through the accusation and asked him, what parts of these accusations do you admit to? Nothing. One of the board members actually asked him, well, you did admit to the fourth cause of action, which actually integrates paragraphs A to double B, or actually to paragraph 25. And yet, we have excuses. Nothing. In his own petition, he says he admits to all or some of the allegations in the accusation, but again, we don't know what those are. In his own petition, he says that he was not guilty or he did not commit any misconduct. Then what's the point of this hearing? Why are we here? The point of this hearing is rehabilitation. What did you do wrong and how it will never happen again? There's no evidence to that fact because we didn't even pass the first prong. We don't even know what he did, according to Dr. Jimenez. A petition for early termination is only granted to those who are the best of the best, those that don't just merely comply with some of the conditions of probation. You have to exceed it. In this case, Your Honor, and members of the board, the CPLEE exam that he took the first time was a failure. and had to retake it. This probation, furthermore, is extended to 2019. I think after hearing Dr. Jimenez's testimony here today, we're going to need each and every one of those days, at least in my part, in the Attorney General's office's view and opinion, to safely protect the public. There is no way I could recommend an early termination in this case. I have nothing further, Your Honor.
All right, Dr. Jimenez, because you have the burden of proof, you get the last word, please, briefly.
Relative to the fourth cause of action, I certainly, and I will say that my attorneys did say to me, when they read the accusation, this is death by 1,000 cuts. I'm sorry, this is death by 1,000 cuts. I cannot, in good conscience, admit to something that is erroneous or misrepresented. I answered the AGO's question on those points he asked me to the best of my knowledge and recollection. It would be a fair statement to say the events as represented in the accusation are not all correct, and I've done my best to inform the board of the accuracy as I lived it, of those comments and my behavior and my conduct. I will stand by my closing statement. My conduct, again, that one statement about my conduct, I read that to mean maybe a DUI or some sort of sexual impropriety with a past client. That's how I viewed that, and that's why I answered it in that way, where I negated that my conduct was related to the case. That was, again, I misunderstood how to respond to that question. It certainly was my conduct, and it certainly was my decisions and how I moved through that case. At every case, that case was filled with ethical and legal dilemmas, as most of them are, this one in particular. I'm open to any further questions from the board.
Right. Is the matter submitted for the board's consideration?
Before we do, Your Honor, I'd like to submit a request for a protective order sealing confidential records, and I have an order in play as well, Your Honor.
Yes, please. If you would hand that to me, I will sign it.
Thank you, Your Honor. And I'd like to note that the petition has no objection to the sealing,
All right.
if I may.
Yes, and just briefly for the record to explain, the protective order will protect confidential records. This is a public hearing. These records could be requested, and to the extent that they contain confidential information, this protective order will in fact protect those records. I'm signing the order, and I will provide the document to Mr. Tan to have a copy made that will be included in the file, and so neither of you will get an additional copy. It will just be served on the record.
That's fine, Your Honor.
All right, then. The matter is submitted. Dr. Jimenez?
In closing, I just would like to thank the board and Your Honor for the time and consideration.
And the matter is submitted?
Yes.
All right. Mr. Tan, the matter is submitted?
Submitted, Your Honor.
All right, the matter is submitted and the record is closed. We are off the record. All right, as I mentioned, I've signed the protective order. And I also have a copy of the form that gives information on how to obtain a transcript of the hearing. If you wish to get a transcript of the hearing, once you get a copy of that form, you are free to go.
Thank you, Your Honor.
Why don't we take a 5-minute break while council has an opportunity for the petition hearing of Dr. Case.
Right. On the record. Right. Good morning. We are on the record. It's February 15th, 2018, and the matter of the petition for early termination of probation of Kenneth Case. This matter is being heard before the Board of Psychology, Department of Consumer Affairs, State of California, Office of Administrative Hearings, case number 2017-120-855. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings. I'm presiding over the matter this morning. We do have a quorum of the board present. May I please take the appearance of the Deputy Attorney General?
For the Attorney General's Office, Deputy Attorney General Jansen Tan, T-A-N Tan.
And Dr. Case, you're here representing yourself today, is that correct?
I am.
All right. So I'm not sure if you had the benefit of sitting in on the first hearing, but I'm just going to briefly remind you what the ground rules are today and how this hearing is going to proceed. You're here today because you have filed a petition with the board seeking early termination of your probation. The board members have the benefit of the petition package that you've submitted. What the board is most concerned about is the rehabilitation efforts that you've undertaken since your license was disciplined. So you don't need to read documents in your petition package, but if you'd like to highlight any information that you want the board to be aware of, please do so. The Deputy Attorney General will provide me with the petition package, and he'll give an orientation of the petition documents and a history of your license and discipline. You'll then have an opportunity to present your case. If you brought any documents, additional documents with you, you may present those at that time. After you're done presenting your case, then Mr. Tan will have an opportunity to ask you some questions, and then the board members will also have an opportunity to ask you some questions. And then you may give brief closing remarks. If you have any objection to any of the documents that are contained in the petition package, please let me know. If you have an objection, I will get more information from you and then make a ruling on whether or not a document's going to be considered by the board. Additionally, if there's any questions that you object to, please let me know, and I'll decide whether or not you should be instructed to answer those questions. As you know, we have a court reporter here. She's taking down everything that's being said. It's very important that you speak up nice and loudly so she can hear you, and that you speak slowly so she can get every word, and to make sure you wait until any question that's being asked of you is finished before you answer, so that we're not speaking over each other. All right?
Yes.
I cannot give you any legal advice during this proceeding, but if you have any questions about the procedures, please let me know. And if I can answer the question, I will.
Thank you.
All right, Mr. Tan.
Thank you, Your Honor.
And I do not have the petition package.
I will introduce it, Your Honor.
Thank you.
Just for the benefit of the record, Your Honor, members of the board, Your Honor, again, I am appearing on behalf of the Attorney General pursuant to Government Code Section 11522. I'm here to assist the panel in fact-finding. My role is not adversarial, but it's intended to protect the public interest. I'm here to ensure that the panel has adequate information which to make a decision. With that, Your Honor, I would like to introduce the petition for early termination of probation of Dr. Kenneth Case, Ph.D.
Yes.
If I may approach, Your Honor.
You may.
Yeah, I'd like to start out with introducing the jurisdictional documents and walking the board through this petition. We have Exhibit 1, which is Dr. Case's petition. It has his opening statement, his narrative statement, disciplinary action information sheet, and evidence of rehabilitation. He also attached his probation practice monitor treatment information and other attachments to his petition. Exhibit 2 is the notice of hearing. It purports that today's date and time at the state capitol is the date and place of today's intended hearing. Exhibit 3 is the decision in order adopting the stipulated settlement, and the stipulated settlement has, as part of its attachment, the second amended accusation. The second amended accusation begins at AGO 0066. Briefly, Your Honor, the decision was effective October 8th of 2015. The penalty imposed or stipulated upon was revocation of license, revocation state, 5 years probation with other terms and conditions such as psychological evaluation, a practice monitor, standard terms and conditions. The second amended accusation, which starts at AGO 0066, charged petitioner with gross negligence and subjecting patient DS to sexual abuse. He was also alleged to have violated several APA ethical standards. That include sexual harassment, failure to avoid harming the patient, and failure to give informed consent. Again, briefly, Your Honor, this case, the genesis of this case was that the petitioner was consulted by patient DS for didactic therapy as part of patient DS's psychology master's degree academic requirement. At patient DS's first therapy session, petitioner told patient DS that he appeared to make himself powerless and not challenge people who oppress him. I guess he seemed meek. Petitioner asked DS if he would like to role play. Petitioner did not discuss the extent of this alleged role play. Petitioner asked patient DS to get down on his knees on the floor and raise his arms in supplication toward petitioner. Petitioner stood on a step stool, making DS face petitioner's crotch. Petitioner told patient DS that petitioner had the power and asked what patient DS felt like. Patient DS was overwhelmed with the intensity of the role play and kept his face facing towards the floor. While respondent implored him to respond to his power, petitioner then slid his arm in his jeans and stuck out a finger from his pants, replicating a penis. Petitioner began to swivel his hips while waving the finger, saying, "I am pissing all over you. What are you going to do about it?" Patient DS was uncomfortable, understandably, with the role play and went and sat on the couch. Petitioner returned to his chair and did not debrief patient DS. Moving on to the next exhibit. Exhibit 3, we have the probation report. And exhibit 4 as well. Exhibit 4 rather, and 5 would be the probation intake report and also the probation report. So exhibit 4 is the probation intake report, which shows petitioner's initials saying that he understands the stipulated settlement. And exhibit 5 is the probation report. Dr. Case completed the condition precedent, the psychological evaluation, which is also a part of this application. His probation was briefly told. It was told from October 8th, 2015 through October 26th of 2015. Another noteworthy item in his probation report was that condition 19 on AGO 0081, it's noted that on or about March 24, 2016, Dr. Case was issued a violation notice for not submitting a quarterly report of compliance on time. The quarterly report was due no later than January 7 of 2016, and Dr. Case did not submit this report until on or about April 3. However, Dr. Case is now in compliance with this condition and no further action has been taken. Exhibit 6, Your Honor, is the notice of late reporting of non-compliance for missing the quarterly reports. Exhibit 7 is the CV of the board evaluator in this case. Exhibit 8 is her report. Noteworthy in this report, on AGO 154, She finds that Dr. Case is extremely remorseful and finds nothing that would conclude or that would question Dr. Case's ability to practice psychology. On Exhibit 9, we have the evaluation by Veronica Thomas, PhD. No,
Sorry, Mr. Tan, that's not included in my petition package. It says withheld on the exhibit.
yes, Your Honor. I think, I believe because of confidentiality reasons, I think that was withheld, Your Honor.
So it's not being presented?
Your Honor, it looks like it's we are not going to present that as part of the exhibit.
So then I'm making that as a notation as withdrawn?
Yes, Your Honor, we are withdrawing that. Your Honor, do you have Exhibit 10?
I have a single page Exhibit 10, July 22nd, 2017 letter.
Wonderful, Your Honor. We are going to present that because that is relevant to the educational review of Dr. Case,
All right.
which shows that he has completed that condition. Exhibit 12 is the practice monitoring strategy and CV.
So you skipped Exhibit 11.
Oh, I'm sorry, Your Honor. Exhibit 11 is the CV of the of the practice monitoring evaluator, Your Honor. And Exhibit 12 is the actual report, the practice monitor certification. Exhibit 13 is the practice monitoring quarterly verification form. And Exhibit 14 is the certificates of completion by Dr. Case's continuing education. So we did withdraw number 9, I believe, Your Honor.
Exhibit 9, yes. Just so we're clear, on the exhibit list, what it says is request to be sealed, but but I don't have the document, so I just want to confirm that in fact it's been withdrawn.
For now, Your Honor, I'm going to ask Dr. Case if he's okay with releasing this, and then I'll probably request a sealing order as well, Your Honor.
All right, we'll have you do that maybe during a break or off the.
Perhaps in the interim, Your Honor. I just want to make clear that Dr. Case is okay with this being released, at least to the members of the board, and that I neglected to explain to him the process of sealing, Your Honor, so I'd like to explain it to him before I introduce it, Your Honor.
Yes.
With that said, Your Honor, it is the petitioner's burden to meet this petition for early termination of probation. At this point, Your Honor, we would like to rest, but we do reserve the right to recall the petitioner for cross-examination. And may I take this brief moment, Your Honor, to ask about Exhibit 9 and explain to him the process of sealing, Your Honor? Can we go off the record for 5 minutes, Your Honor? I should have done this before we went on the record, Your Honor. I apologize.
Is this because you want to question him about the document?
No, I just wanted to ask him and explain to him the sealing order and if he's okay with us releasing this psychological evaluation.
We'll go off the record for just a moment. Off the record.
Thank you, Dr. Case. So Exhibit 9.
And Mr. Tan, just make sure your microphone.